Planning call about this panel a couple weeks ago. For a while I thought nobody was going to pay attention to this piece of issue one, the piece that provides the opportunity for Ohio's prisoners to earn up to 25% off their sentence for engaging in rehabilitative or other programming. We'll hear from panelists to talk more about the specifics of what that calls for and how it relates to what we currently have in place in Ohio. But the issue has gotten on a broader radar screen, I think, because Attorney General Mike DeWine, now candidate for governor here in Ohio, has started running ads against this piece of issue one, talking about how, I think in the words of the ad copy, drug dealers and human traffickers would be getting out early were issue one to pass and become law here in Ohio. That's not uncommon to hear conversations in the political discourse about these issues, but they're always incomplete. They're always insufficient for a thoughtful group of lawyers or lawyers in training to really understand what's at stake and to be in a position, as I often think we have a responsibility to do, to communicate effectively with our friends and neighbors about what a provision really means and what we should think about it. And wonderfully, we have three people here, two Ohioans and a fly-in from, dare I say, the swamp that hasn't quite yet been drained in D.C., Shon Hopwood, who we're very fortunate to have to give his perspective on the broader issue, because there's an ongoing fight at the federal level over enhancing the opportunity for prisoners to provide, to earn additional time off their sentences. I've said about to each of the panelists that I'm going to let them mostly introduce themselves. You can see their names, but I'll say their names. Shon Hopwood, David Phillips, the Union County, Ohio prosecuting attorney, and Sasha Naiman, attorney and Deputy Director of the Ohio Justice and Policy Center. I'm going to let them describe their background as leads to their perspective on this part of issue one. But I want to do a little more general background, especially for a law school audience, because it's something that I think is probably, at least as I see it, the most important thing for lawyers and lawyers in training to be able to talk intelligently with the lay public about. And that's the reality that most jurisdictions, that's a slight overstatement, but many jurisdictions, Ohio and the federal system, most notably for this conversation, no longer have this thing known as parole. And I think that's something that you'd be perhaps surprised, maybe you yourself didn't know this for sure before coming to law school. We have this incredibly long-standing belief, mostly inaccurate belief, that the sentence announced at sentencing isn't really the sentence, that the offender will have a chance to earn parole and get out early, maybe a lot early, maybe a lot early. And the reality is, in the federal system, in 1984, sentencing reform was passed that completely eliminated parole from the federal system. So if anybody ever says to you, oh, they're going to get a federal sentence, but they'll be paroled earlier, no, they won't be. There is no such thing as parole in the federal system. What there is the opportunity to get up to 15% time off, generally known as good time, although Shon can speak to that more directly. That's been in place now for a better part of 3 decades in the federal system. In the state system in Ohio, it was, I think it was SB 2 back in 1996, where Ohio followed that same trend, a trend that a number of other states have followed as well, also eliminating parole. Now, that's incomplete for the story of Ohio because, of course, there are some offenders who were parole eligible, sentenced before a change of law that still have the possibility of parole because you can't take that away consistent with ex post facto law. In addition, Ohio has other mechanisms for adjusting your sentence, judicial reconsideration and the like, and so it's a little bit more complicated to tell the complete story in Ohio. The key is to understand, in many respects, good time credits or earned time credits, or this debate going on now here in Ohio around issue one, going on around the federal system, is in many respects the modern version of a debate over parole. The modern version of both what do we think prisoners can and should be allowed to do while serving their time, and how should that impact their ultimate release date, but even more broadly, how does that relate to their release back into the community and risk of recidivism. And for me, this is not just what makes issue one obviously a sentencing reform, criminal justice reform initiative writ large. It's an issue that actually is playing out across the country in a variety of different settings in a variety of different ways. And so those of you here thinking you were just going to hear about a little part of a little issue here in little old Ohio, no, it's the entire criminal justice system we're talking about today, but with the issue 1 provision being kind of the first segue into it. And so with that background and introduction, I'm going to now pass it on to Sasha to give what I expect to be a proponent's view of this part of issue 1. Then David will speak about what I expect to be an opponent's or different view about issue 1, and then Shon will add his perspective, looking at this both through the federal lens and across a range of debates over these issues. And so, without further ado, we have this mic. I'm loud enough without it, but...
Good afternoon. Can everybody hear me? All right. Hi, everybody. I'm Sasha Naiman. I'm an attorney at the Ohio Justice and Policy Center. To give you a little bit of background, OJPC is a nonprofit law firm that helps to create a fair, redemptive, intelligent criminal justice system. We've been around for 20 years. We help people who are incarcerated, and we help people with criminal records who are out in the community. We've been doing this work around criminal justice system reform here in the state because we want to switch away from the status quo idea of caging and separating people and move toward the idea of what's common sense, what's real safety, what is health. When somebody has contact with the criminal justice system and they return to the community, and over 90% of people who have contact with the justice system do return to the community, what will they be like? How do we ensure safety and health in the community? We've tried in Ohio the war on drugs. We've tried the war on crime. We didn't win the war. Ohio didn't win the war, but a lot of people lost. A lot of communities lost. And that's the reason why we're trying to shift the mentality. Right now we have about 50,000 people in our prison system. We're at 132% capacity. We are literally caging and stacking people. The number of women in our criminal justice system has gone up tenfold in the last 40 years. All of the numbers have gone up hugely in the last 40 years. We're spending about $1.8 billion on our prison system through the Department of Rehabilitation and Corrections. And it's not working. Issue 1 brings a solution. And issue 1 does 4 things. First is it changes how we look at earned credit. And I'm going to talk in detail about that in a second. Second thing that it does is it changes, in Ohio, all drug charges, drug possessions, besides some bit of marijuana, are felonies. What issue 1 will do is we'll take the lowest level of possession, those lowest felonies, and move them into misdemeanors, so a person can't get a misdemeanor. It makes it, when a person gets a probation violation, which is non-criminal, like they missed some appointments, they applied to 12 jobs, not 32 jobs, they can't be in prison for it. So you can't cage people for doing something non-criminal on probation. And the last part is it takes all the money that's saved by taking people out of the prison system and puts it into treatment services, into reentry services, and into services for victims. So it's about healing, making the earned credit piece, currently, it works like this. You can get up to 8%, earn back 8% of your time. And the system allows you to either get 1 day per month or 5 days per month. So a person, no matter how much programming they're doing, will either get 1 or 5 days, depending on when they were sentenced. What we're proposing is a system where a person can get up to 25% of their time, 25% credit, earn it back by doing programming. And the time they earn is actually linked to how many days they're spending in programming. So the more days you're spending learning, the more days you get off, and it's 2 days of programming, it's 1 day for that 25%. So why is this a good idea? First, earned credit works. We know it works because the last 3 directors of our prison system have been fighting to expand our earned credit system. They've been doing a lot of work to make sure the programs we have in our prison system are evidence-based. They've actually gotten studies of their programs to get rid of the non-evidence-based programs, only to keep the good programs. Studies have shown that, first, participation in earned credit programs makes prisons safer and teaches people the skills they need to not recidivate. But on the other end, early release programs actually don't increase recidivism. So there have been multiple studies, and if we let people out earlier than the maximum, will they be more likely to reoffend?
And the answer really across the board is no. In fact, some studies show that they're less likely to recidivate if they can learn these skills. Increasing the ability of people to earn their freedom also then relieves the pressure on our bloated criminal justice system. It relieves overcrowding by linking an accelerated release to a person's self-improvement. So people will be getting the skills to get jobs, to be safe in the community, getting treatment for drug addiction. And only then are they able to earn their way out. And I want to say this is a very cautious and conservative proposal. The only way somebody gets that 25% essentially is if they're working from the very first day, they get in, they somehow magically are allowed into a program, and they're working at a full-time rate, like 4 weeks a year, 4 weeks a month, 5 days a week, like a full-time job. Every month, from the beginning of their sentence, every single month until the end of their sentence, they have to work a full-time job. That's the only way to achieve that 2 days of work to 1 day off to get your 25%. Below that, people can work up to different amounts. Also, in our in the issue 1 proposal, it's not for every person, it's for people who will be released. So again, we're targeting to make sure the person who does get out, it's not the death penalty person, it's not the life in prison, it's not murder, rape, child molestation. It's a person who will be in the community. We know that. We know this is a person who will come back out. Are we ensuring they're incentivized to get programs? And that's the last piece. Is the current system doesn't incentivize people to go to programs. Either they're in the category of people who are getting almost no credits for their work. They can get less than 2 weeks off per year. They're working every single day, so it's not an incentive. The other group, they get a little bit more credit, but the 8% cap is so low that they can't use it. So you have one group that's not incentivized because it doesn't count for anything. In fact, DRC doesn't even, Department of Rehabilitation and Corrections, doesn't think about earned credit when they're forecasting the number of people in prison because it's such a small amount that you can earn. And the other group, they can earn a little bit, and there might be some incentive there, but then it drops off because they can't, they hit their cap, they can't get out of any program. With this program, every single day that you are doing some kind of programming, you are improving your skills, you are making the prison community safer, right? Because when people are busy and they're doing things, they're not sitting around. But also you're able to chip away at your final sentence. So I'll end with this. This part of issue 1 is around people who are going to return to the community. We want them to come back to the community taking programs that are going to make them rehabilitated, treated, train them for jobs, give them the skills that will allow them to not recidivate. Or do we want them to sit around, be caged, be separated, and then come back, still broken, still damaged, and potentially just as dangerous?
Thank you. All right, Dave. Come back to follow.
All right. Well, good afternoon. My name is David Phillips. I'm prosecuting attorney for Union County. I will tell you that I have been here before, but the last time I was here, I was sitting out there, not as I'm a graduate of the Ohio State University College of Law. The building did not look like this when I was here. I will tell you that. It was much nicer now. When I
can't believe that when they live around.
Trust me, it's much nicer now. I actually came here from Michigan. I didn't go to the University of Michigan where I graduated from Michigan State, but I root for the Buckeyes, so I just want you to know that. We have some who doesn't root for the Buckeyes, but we can talk later. So just when you're evaluating what we have to say. I've been a prosecutor for 30 years, and before becoming a prosecutor, and the elected prosecutor now for 14. Before that I did some, it was in private practice and did criminal practice. So I've seen a little bit on both sides. I was past president of the Ohio Prosecuting Attorneys Association and currently a director of the National District Attorneys Association. And so I get to talk to prosecutors from around the country who are looking at issues like this. I will tell you one thing. If I agreed with everything, I don't, but if I agreed with everything that Sasha had to say, I would still tell you to vote against State Issue 1. And the reason is this, because of the mechanism. What we're doing is we're changing Ohio's Constitution. This isn't an initiative petition to enact a statute. This is actually changing Ohio's Constitution. And the reason that concerns prosecutors and a number of other groups is because it's a difficult thing to do. It's so difficult, in fact, that the proponents have already spent $4.6 million just getting it on the ballot, and are going to spend millions of dollars for advertisements in favor of State Issue 1. Now, that money isn't coming primarily from Ohioans. That money is coming primarily from groups outside the state. George Soros-funded groups, millions of dollars. Coming from the Zuckerberg Foundation, again, millions of dollars. And coming from D.C., like hundreds of thousands of dollars. So really, it's not an Ohio initiative. It's coming from out of state. It's based on California Prop 47. I will say, look at what some of the things that California Prop 47 has done, among other things, I'm not suggesting this is the only reason, but among other things, the city of San Francisco is now cleaning up the streets, spending $3 million a year to clean up the fecal matter as well as needles on their streets. I don't believe that some of the things that are at State Issue 1 really promote safety, but really what we're going to focus on here is the 25% reduction. Now you have to understand, and again, I've been a prosecutor for 30 years. When I was first doing felony prosecution, we had what was called indeterminate sentencing. And the professor mentioned prior to Senate Bill 2. So in Ohio, if you committed a felony of the second degree, such as felonious assault, you could be sentenced for a term of 8 to 15 years. And there was up to a 1/3 administrative reduction on that, off the minimum term. So after a conviction, the victim would say to a prosecutor, when is this person going to get out? If I'm afraid, I want to know. And our answer had to be, I can't tell you. I don't know. Because there's an administrative off the minimum term, again, 8 to 15 years. So it could be anywhere from, say, 6 years to all the way to 15 years. I just can't tell you. And that's the way that sentences were imposed for a long time in Ohio until approximately 1996. And through efforts, and these are not just prosecutors' efforts, but through prosecutors, defense attorneys, the legislature, Senate Bill 2 was enacted. And Senate Bill 2 changed Ohio's sentencing structure dramatically. We went from, generally speaking, indeterminate sentences to determinate sentences. And when the legislature picked the sentencing range, they picked the low end of the range. So the low end of pre-Senate Bill 2 was 8 years on a 8 to 50 on a felony 2. That's now the high end of what can be imposed in Ohio for a felony of the second degree. The penalty now is 2, 3, 4, 5, 6, 7, or 8 years. But what happens during sentencing is the judge will take a look at a pre-sentence report, look at the defendant's record, look at the impact that the crime has had on the victim. And the only thing the victims really benefit here is through some money. But victims don't benefit otherwise through State Issue 1. But in terms of sentencing, the judge would look at all those things and consider, and is required to consider, under the purposes and principles of sentencing, the minimum sanctions necessary to punish the offender, protect the public from future crime by the offender and others, in other words, deterrence. So those are the factors that the judge would consider, and then select a range, select one of the sentences from that range. So the judge could pick 2 years, the judge could pick 8 years. In more serious cases, if there was an RVO spec, a repeat violent offender, somebody had prior felony offenses of violence, then there could be a specification added, which could add an additional 1 to 10 years at the discretion of the judge. As a matter of fact, we just convicted someone who was sentenced to 18 years in prison. What did he do? He assaulted his girlfriend. When he did that, he punched her in the face repeatedly. When he punched her, broke her glasses, causing her to, the glasses pierced her eye. She lost her eye. She now has a glass eye. This is his 3rd felony offense. He was convicted as a repeat violent offender. Okay? Well, by the way, you can get up to a 25% sentence reduction under this issue. So, under Senate Bill 2, it was called truth in sentencing. And finally, prosecutors can say to victims, when is he going to get out? He's going to get out when the judge says he's going to get out. When the judge has imposed the sentence based on the sentencing factors that the legislature has established. He will get out in 2 years, he'll get out in 3 years, whatever the sentence imposed. Truth in sentencing. And the Ohio Sentencing Commission at that time said Ohio's sentencing structure is the most honest in the country. Okay? The most honest. Now, since that time, it's been chipped away. And what we're looking at here is essentially a constitutional get-out-of-jail-free card. We're looking at a 25% sentence reduction for almost everybody except those convicted of murder, those convicted of rape, and those convicted of child molestation. We're going to have to litigate what child molestation is because that's not a crime. in the state of Ohio. Child rape is. But child molestation is not even defined in Ohio. So we'll have to see what that means. But we can tell you what we don't think it means, because this provision, this constitutional provision also says you have to construe it in favor of liberalization, in favor of the defendant. So child pornographers, they're not molesting a child, they're not physically doing it, they probably qualify too. Human traffickers would qualify. So when Mike DeWine's commercial has been referred to, are out there, we're talking about serious felons that can get up to a 25% reduction simply by going to class or attending or working. So when we talk about, and there's been a lot of studies, and I tell you, to suggest that this is the only answer, it's not. As a matter of fact, the Ohio Sentencing Commission has a subcommittee, Justice Reinvestment 2.0, we're already looking at the Ohio sentencing structure. And it involves the Public Defender's Office, it involves prosecutors, legislators, judges, it involves policymakers. I believe even their organization is on that committee. So we're taking a reasoned approach, because if you look, this is the quick guide to felony sentencing. It's about 9 pages. Ohio sentencing structure really does need some reform. It doesn't need the Constitution change. When we talk about 25% off being effective for recidivism, well, what we have to do, as lawyers, or lawyers to be, we have to define it. And recidivism to the prison system is, we don't have them back in our system in 5 years. Recidivism to a prosecutor is, you don't commit another crime. So it depends, and I will tell you this also. And so when you talk about rate of recidivism, you need to understand, what are we talking about here? Not going back to the prison system or not committing another crime. Okay? So that's on how you define the term recidivism. When you look at the proposal, it also says in here, that they get, for each day that they participate, they get half a day. Now, I don't know if that means 8 hours or just attending one class during the day. I'm guessing, because it has to be liberally construed, that somebody goes to an anger management class during a day. They get half a day off of their sentence. The focus of this is really on the offenders. And other people in the criminal justice system really have nothing to do with this. If you recall, and I'll wrap up here, if you recall, just recently, Ohio voted 83% in favor of what was called Marxism. Now, that also amended Ohio's Constitution. And that caused a lot of prosecutors some concern, because the last 3 times we've had Ohio's Constitution either amended or sought to be amended, one was to promote gambling in the state, and so now we have our Constitution is a third gambling. And then it was victims' rights. We already had a constitutional provision on victims' rights. We had a chapter 2981 on victims' rights. But an out-of-state interest came in with a lot of money. Now our Constitution has it in there. I'm not opposed to that. I think it really constitutionally puts in provisions for 2981. But now we're trying to change the Constitution again. And the problem is, from our perspective, changing it back is hard. We're not going to get people with millions of dollars to put it on the ballot. We have to use the legislature to 2/3 and say both houses, we want to put it on and change the Constitution. It's hard to change. If change needs to be done, I'm not suggesting that no change needs to be done. I think we're working toward that on various committees, the Sentencing Commission, and study committees. If change needs to be done, it needs to be done legislatively by the people that are elected by us to look at those, study those issues, but not funded by us.
Shon. Hello, and I am not an Ohio State fan. I'm a Nebraska fan, but you can't hold that against me. And Park has been beating up on us bad enough for the last few years, so I should be viewed as a friend. I am a law professor at Georgetown. I work on criminal justice issues, and if you've heard about my story, I've had a traditional path into the law. Serving 11 years in federal prison because I robbed a bunch of banks when I was a foolish 20-year-old. And saw a lot of things in the prison system. No one in my family had ever been to jail, let alone to prison, and I think we thought, like a lot of Americans, that prison was where the evil people go. soon and realized, well, it's not evil people, it's mostly just people who, for whatever reason, made really bad choices, but most of the people I saw in my time in custody had the potential to be redeemed. They just needed a little bit of help. What's the best way to help? Well, we know that our recidivism rates in this country, if measured by the number of people that get out of prison and commit new offenses within 5 years, is astronomically high, higher than most other similarly situated countries, and ranges anywhere from 45% to 75%. So how many government programs do we know where 3 out of 4 times they fail and we continue to reevaluate what we're doing? Don't answer that, because it may turn out that it's more than just the criminal justice system. How do we get people to come to prison and turn their lives around so that when they get out, they are not committing new offenses? This benefits everyone. Taxpayers, when people get out and don't commit new offenses. Crime victims. I've never met a victim of crime who said, yes, send that person to prison, make them worse so that when they come out, they're even a more vicious, violent offender. It does not benefit any of us to have people come out of prison worse off. But I'll tell you, the cruel irony of our criminal justice system is the longer people tend to spend in corrections, the less likely they are to be corrected and come out as law-abiding, successful citizens. The reason for this is not hard to figure out. I like to refer people to a very profound media outlet called The Onion that once had a fictional warden, a story about a fictional warden who said, I just don't understand why we put this person into an environment where they are in threat of physical violence every single day for 15 years, and we dehumanize them, and they don't come out well-established, law-abiding, successful citizens. I can't figure this out. Well, that's exactly it. When someone is convicted of a crime, they don't just magically wake up one day and decide, I need to change. In fact, it's always astonishing to me that there is nothing formalized in the criminal justice process where the defendant sits down and talks with someone about what factors led me to going to prison, and what can I do today and tomorrow to make sure that I eliminate those factors so that when I get out, this will not happen again. And it rarely happens in the criminal justice system, and it rarely happens in prison. And so that is why we have the recidivism rates. One is we tend to warehouse people rather than provide them with meaningful rehabilitation programs, and we don't incentivize people. People in prison respond to incentives just like anyone else does. And a lot of times it's hard to take someone who has been in and out of prison several times and motivate them to kind of wake up and seize the day and work on self-change. And so we need incentives to get people to do the right things. This bill and this constitutional provision that you're talking about in Ohio is largely being mirrored on the federal side. I have worked with the White House for a year on a bill called the First Step Act that will require the Federal Bureau of Prisons to put meaningful rehabilitation programs into the prison and then ties those to incentives. What's the best incentive you can imagine someone in prison would find the best incentive to get them motivated to do something? I can tell you, it's kind of how I started my career in the law. It wasn't when I got a job in the law library that I automatically decided I wanted to start practicing law from inside the prison to help other people. No, I started studying the law because the Supreme Court handed down a decision that I thought, and everyone else did, could lead to a sentence reduction. So I had a lot of motivation to try and self-study the law. People in prison need that motivation in order to take meaningful rehabilitative programs and lower their risk of recidivism. The federal side does the same thing. In fact, this bill increases both good time, which actually cuts a sentence short, and provides up to 15 months or 15 days of earned credit time for every 30 days someone programs. So the federal bill actually does 50%. This is not a bill that is being sponsored solely by the George Soros and the Zuckerberg and the Facebooks. The American Conservative Union Foundation both supports the First Step Act and the Ohio bill. Our street, right on crime. I like to say criminal justice reform is the last bipartisan issue in America. And the reason it's so is because everyone realizes the American criminal justice system is not nearly as effective than it could be if we changed up some of our policies. We know that for every dollar, say, Rand Corporation came out with a study just a few years ago that says every dollar we spend on education in prison saves $4 or $5 on the back end when someone gets out and does not commit a new crime. We don't have to pay for the prosecutor, the public defender, the probation officer, and the judge, and then the $30,000 or $40,000 it costs to reincarcerate that person. And so what we've got to get out of the business is thinking about short-sightedness and thinking that the only way to fix the crime problem is to lock people up and keep them there for a long time. That, if you look at the incarceration rates in the United States, you know what country our incarceration rates have mirrored for the last 30 years? Canada. Theirs went up, went down, just like ours. The difference is they have locked up a fraction of their citizens. The United States literally almost leads the world in the rate in which it incarcerates its citizens. And again, if it was productive, I would probably still be here saying it's unjust, but it turns out it doesn't always work. And more economists now with new data have realized that the link that we thought was very strong between the incarceration rate and the crime rate, it's not linearly, it's much more tenuous than we thought. Anyone want to know what the biggest reason is why the crime rate goes up? It has nothing to do with the number of people we incarcerate. The economy. What other factors? How many police we actually put on the ground and how they go about the job of policing impacts the crime rate much differently than the number of people we lock up. And we know this now because we've had about 10 to 15 states in the last 5 to 10 years who have both reduced the prison population and watched as their crime rate still went down. Some of the states aren't ones that you normally think of involving criminal justice reform. Texas, Pennsylvania, Louisiana just passed reforms last year, Maryland, and they have watched reforms also be tied to less crime, so we know that we can do this. The question is, how do we get people in prison to be rehabilitated? A couple different things. Incentivize them. Best incentive is cutting their sentence short. I really believe this. Earning your way to freedom is a way to incentivize prisoners in the federal system and Ohio system. I can't imagine it's any different. You know, no matter what I did in federal prison to show that I had been rehabilitated, it didn't lead to 1 day shorter on my sentence. And you can imagine that some people have to have that incentive before they will do it. In fact, we know this. We know this because the residential drug and abuse treatment program in federal prison is the most popular prison rehabilitation program the feds have. It's the only one that has been shown to reduce recidivism. And you know why it's so popular amongst the people in federal prison? It's because it's one of the few programs that if you committed a nonviolent offense, you go through the treatment program and successfully complete it, you get a year off your sentence. So if we know this is what works, what I like to say is, why wouldn't we want to incentivize everyone who has a release date to rehabilitate themselves? And I would say even people that have molested children and committed sex offenses. If we know they're going to get out someday to be your neighbors, why wouldn't we want to incentivize them to rehabilitate themselves so when they get out, they're not committing new offenses? It truly is a public safety issue. If we know people are going to get out of prison, we want them to come out better off. And most of the data I have seen shows that incentivizing people is the only real way to get people who sometimes have failed multiple times in the criminal justice system to actually take rehabilitation seriously. So I don't know a great deal about your bill in Ohio, but the parts that are modeled on the federal bill, there's a reason why it passed overwhelmingly in the House in May, including was voted on favorably by almost every Republican in the House but two. It's the reason why Senator Chuck Grassley, the Republican from Iowa, who no one would confuse with a bleeding heart liberal, is pushing this bill in the Senate. We're hopeful that it will get passed after the November elections. And dare to say, I don't think if this was a jailbreak bill that just gets people out of prison, that President Trump would be willing to sign it. And so I think that more Republicans and more on the right are really coming to grips with the fact that criminal justice practices, many of which are outdated, are not being nearly as successful as they could be, and why this is now a bipartisan issue both in Ohio, Washington, D.C., and across the nation.
Thank you, Shon. I appreciate that. Others have comments, reactions to what's already been said, or back and forth among us. I have questions, but I bet you there are also questions from the audience I want to get to, but first let anyone who wants to respond to something already said.
I think if I would respond at all. I don't disagree with much of what he said in terms of prison reform and rehabilitation in prison. But I would tell you this. Federal sentences are generally much longer than Ohio sentences. And to talk about locking up people in Ohio, you've got to work really hard to get locked up in Ohio, even after committing a felony. And there are now 5 levels of felony: felony 1, 2, 3, 4, and 5, and then classified if it's a homicide. Felony 4s and 5s are the typical drug offenses that we're talking about here, just the possession offenses. There's a presumption against prison. A felony of the 3rd degree, there's no presumption either way. So the judge looks at the record and the principles and say, are you going to go to prison or not? So the majority of the people who come through the criminal justice system aren't going to prison. They're getting community control sanctions. And yeah, the felony 1 and 2 level offenders, the more serious offenders, those are the people that are getting, generally speaking, locked up because there's a presumption in favor of them. And those are the people, we talk about recidivism as if that's the entire way to judge the criminal justice system. That is but one way to judge the criminal justice system. And no, nobody wants to see criminals come out and recidivate. Reentry programs can deal with that. Programs in prison can deal with that. Nobody wants to see the recidivism rate. But the fact of the matter is, if you're a victim, the one thing you want to say is, when is this person going to get out of prison? Am I going to be safe? There are elements of deterrence. There's elements of punishment involved here that aren't being taken into account here. Well, let me just say this. Even again, if I agree with everything you said, I still wouldn't tell you to vote for this issue because it changes our Constitution. We're not changing the United States Constitution on the federal level. We're actually introducing a bill. And if it doesn't work, then we can change it. Not necessarily easily, but it can be changed much more easily than the Constitution. And I don't know what the sentence was in the post for bank robbery. We've never been able to get the feds to take one of our bank robbery cases. We always deal with it locally. But I'll tell you this. He said, it's Shon, right? He said, no matter if I could show if I was rehabilitated. There's no requirement that anybody show that they're rehabilitated here. Only participate. Now, imagine if your classmates came to class every day and signed in, and then at the end of the term said, well, you've never taken a test, you've never passed a test, you really don't know anything about the law, but here's your degree. We're going to put the purple hood on and go off and be a lawyer. You'd be a little puzzled by that. You say, well, I was here every day. Well, you're not a lawyer. You haven't learned the law. Nothing here, when we talk about parole, well, that would, for a parole board, they can look at what was their record in prison. Are they really rehabilitated to the point that they're not a danger to society anymore? There's no safeguard like that here. This is you must, it's a constitutional right. ODRC must give credit if they participate. So, and there's programs such as Raising Dogs. I don't know if Raising Dogs in prison does anything to rehabilitate an offender, but I'm going to guess that they're going to say, look, I participated in this program, it's a community service program, I want my time. So whether or not they are actually rehabilitated really isn't relevant to
stuff, and I wonder if you want to talk to both the issue one as a constitutional amendment and concerns about that, and also the concern on this particular issue that participation without achievement, and I put it that way, still will earn credit for persons in prison.
Yes, I'd love to talk about this.
Okay, good.
All right. So this is a constitutional amendment. Let me tell you about that. OJPC has been around for 20 years in Ohio, trying to get a better criminal justice system. And we are at 132% capacity of our prison system right now. At best, at times, it has plateaued. The people that we have elected haven't created something like this. There have been some reforms. We're proud of the things that the legislature has done, because the incredible growth of our prison system was slightly curbed and became a smaller growth. And what they gave us with earned credit is you went from earning 1 day of credit per month to earning slightly more but being unable to use it because they created a cap. That's what our General Assembly did. In our Constitution in Ohio, there is an opportunity for the voters, for the citizens, to take back that policy-making ability through a constitutional amendment when our General Assembly didn't do it. We've tried. I mean, I can't tell you how hard we've tried. We have met with these policymakers, and there have been many meetings. And we have been there, and we've gone to all of the committees. And this is a once-in-a-lifetime opportunity, I think, for Ohioans to use what exists in our Constitution. That's the ability to get a lot of people, and you're right, it's very difficult, a lot of people to sign on and to vote to get it onto the ballot and to vote for it on the ballot. It's a very difficult move, and it comes at a time when our criminal justice system is so bloated, it's so critical, and we can't continue to say, let's rely on this General Assembly, let's rely on them. They have a lot of their own infighting. Many of you have been following what's been going on in the last few months. They have a lot of their own stuff, and that's on them, and they've done some good things, like I said, in the past. Something like this hasn't come through. And Ohioans have an opportunity, given to them by the Constitution, to do a ballot initiative in just this kind of circumstance. So that's what this is. It is difficult. In some ways, it is a larger measure than trying to go to the General Assembly, but it is the next step, the logical next step after the work has been done. I want to address this question of victims and what do victims want, and to echo Shon, that let's talk about what victims want. I at the Ohio Justice and Policy Center, my role there, most recently with Client Services, has been to work with survivors of sex trafficking. They are the victims of those human traffickers that we see in the Des Moines commercial. You know why they're in my office? Because they have huge criminal records, because they were forced to drug use. Those are the drugs that we're talking about. They were forced to steal. The perpetrators of the crimes against them did some pretty terrible things. I haven't talked to every single one of my clients about this issue, but I've talked to most, almost all of them. Not one of them is opposed to this section. And I'll tell you why. If somebody is a human trafficker and they get 28 years in prison, I'm going to use this number because it's an easy math number. They can sit in prison for 28 years. They're 20 right now. They'll come out. They'll be 48. They'll have sat there doing nothing. And they'll be 48, and they'll at best be equivalent, not worse. If they had worked from the very first day, 5 days a week, 4 weeks a month, every month of the year, no breaks, no vacations for 21 years. 21 years, they would have done a full-time job without vacation, then they get to get out early. And that's where it comes down to the voters. Would you rather this person who has done nothing for 28 years come out, or are you safer with them having worked every single day? It's not a get-out-of-jail-free card. Frankly, everybody who's incarcerated right now can't even get to the 25%, right? Because they haven't been able to work from their first day. This is a level of dedication and participation that even if you don't get something out of it every single day, boy, to get the 25% working without vacation for 21 years, that's pretty significant. And my client who's a victim of sex trafficking would rather that person come out. Because her measure of recidivism is not just about, will he commit another offense? Will he come back to prison? She's thinking, will give against me, right? That's what makes her feel safer. Now, there's victims on different sides, so we can find different stories. I'm telling you my anecdotal evidence. I want to talk about this participation piece one more time. The part of the issue one that talks about doing programming, it specifically says that they have to do appropriate programming, which then can be defined within General Assembly and within court cases. But it's not just that they participate in any kind of program. We specifically put it, it's appropriate programming, which can be worked out. And if you don't mind, I would like to address the out-of-state interest.
Sure, quickly, I want to make sure we have time for questions.
This issue came to Ohio in part because of OJBC and other organizations setting such a good groundwork here that people who are nationally recognized, have national money, wanted to give us the resources to do it. The language you have in front of you in the handout was largely drafted by Stephen Johnson-Grove, who's my colleague, who's sitting right there, who's from Ohio, who has worked with me since I was a paralegal. It is very much an issue within our state. A small nonprofit just doesn't have the funds to do all of this, and we're being recognized, essentially, as a state who's done so much groundwork that we can use this money now for a statewide initiative. But we should look at other states in this sense. All but 4 other states have a way for a person to get out of prison early. We're not unique. But most of them, the way that they get out early is called good time. Good time means you're just sitting there and not getting into trouble. Ohio doesn't have good time. Ohio requires you to proactively participate in the programs that will make you better. So we have right now, with our system of getting very little time and participating in programs, besides the 4 states that just don't have anything, we are among the worst and the lowest. If we were to implement issue 1, we would be in a group of about 18 states that have a very comparable way, 25% or more, that can be earned to come out earlier. And there'd still be 13 states who are letting people out even earlier. You have Alabama, who lets people every month earn 70 days, right? We have Oklahoma. We have Alaska. I mean, there's just state after state after state, I can tell you, that has even broader programs than us. So if we do look outside of our borders, we're really not bad.
Thank you, and I want to make sure we have questions. I want Shon to get a second word in as well, if he'd like, if there's no questions, but throw the hands up or...
Well, no, I mean, what David said reminds me of something that I hear a lot on the federal side, which is an argument from DOJ about mandatory minimums, which is we can't reduce mandatory minimums because it will make it harder for prosecutors to get guilty pleas. I'm not certain we should have as our primary value making prosecutors' jobs easier and talking with victims when rehabilitation, it's a system of corrections. Rehabilitation long-term is the best thing for those victims of crime because then people aren't going to prison and becoming worse and getting out and re-victimizing people all over again. To me, this idea of rehabilitation in prison and trying to maximize that is something that everyone should agree on because it's really a public safety issue. And I think we're seeing now more prosecutors' offices starting to support this. I can tell you several former attorney generals from both sides of the aisle are supporting the federal bill because they think it's a public safety issue. It's not just a crime and punishment issue. That if we're going to send people to prison, the best thing we can do is make sure that when they come out, they're not a threat of committing new offenses. And re-entry is a big part of that, but re-entry is not enough. In fact, part of the problem with our re-entry systems now and the interface with prisons is prisons tend to focus on re-entry the last year before someone's released. That's not when you need to focus on re-entry, and that's not when a person needs to be thinking about their release date. They need to be thinking about that from the day they walk into prison and be incentivized to start changing then, because if you try to just do it on the back end, studies have shown we're just not very effective when we don't focus people in prison on release from the very beginning they get into the system. You can't just fix it through reentry because if someone's been warehoused for 10 or 20 years, their social skills, needless to say, have been deteriorating, and if they don't have job skills or education or something, they're going to have a really hard time coming out. Not to mention the fact that when people do get out of prison, there's a whole new punishment in the form of 3,000 to 4,000 collateral consequences of a felony conviction. Be legally discriminated against in housing, employment, federal benefits, voting. And so to think that we can just not worry about recidivism while someone is in and not incentivize people and fix it when they get out, I've just never seen a place where that actually works.
Thank you. Questions? I got two back there.
This man, for purposes of repeat offenders, so if we're talking to somebody who has several different nonviolent drug offenses, what happens in that sentencing line? Are they all going to be terms of misdemeanors?
Oh, so the question is about when felonies become misdemeanors?
Right, and multiple times, so like day one, and then a year from now, get another nonviolent drug crime.
Yeah, so what issue 1 will do is if you have a drug possession, regardless of how many drug possessions you have. In Ohio, it's based on the amount you have. So currently, based on the amount of drug you have, it goes felony 1, 2, felony, biggest one, felony 1, 2, 3, 4, 5. Now those felony 4 and 5 level possessions will become misdemeanor level. Now, what does change depending on the amount of times you're getting into trouble is the sanction you get. So if you get stopped with a drug possession and you have no other criminal activity, it's not that you're at the same time stealing from somewhere and they can hold you on that, you weren't assaulting somebody, they can't keep you on anything else, so you're only doing that possession. You haven't had more than one other possession in the last 2 years, this is your second one in 2 years, your sanction will be probation. Once you hit your third one in 2 years, then you can get jail time. Now, the first 2 times in 2 years, if you have something else, so I'm also stealing, I have drug paraphernalia, I have something else that you can hold me on, they can still be incarcerated for that. So we're talking about people getting misdemeanors who have the smallest amount of categories that we have in our law being pushed to misdemeanors and not putting people behind bars if they have no other incarcerable offense. They're not having possessions very, very regularly, so it's only one other time in the last 2 years. And after that, if they're on probation and they're too violent, you can still jail them. So what you can do as a repercussion to that person who has one other is tell them to go to a treatment facility, so sentence them to a treatment facility, to house arrest, to whatever, and then after that, they're still graduating sanctions, I guess. The third time, though, in 2 years, you can jail.
And actually, we disagree with that, Shon, and here's why. In order to have a conviction, and this, I think this is a drafting error, and I apologize if you draft it. The Supreme Court, Chief Justice came out, which is unusual, and said, if State Issue 1 passes, the consequences for Ohio would be catastrophic as appropriate. All the judges, associations, prosecutors, police, corrections officials, victims, all are coming out against this. And there's a good reason for that. But when we focus on this particular aspect, that's what you're going to hear. Is, oh, it's just low-level offenses get misdemeanors instead of felonies. Well, in order to have a conviction, you have to have a charge. And what this says in our Constitution now, in no case shall, for possession, in no case shall any offense be classified as a misdemeanor. In no case. And then it goes on to say, in another section, this shall not apply to convictions for first, second, or third degree felonies. Well, you're all lawyers to be. But you cannot have a conviction until you have a charge. And there will be no charge in Ohio higher than a misdemeanor. Therefore, there will never be, no matter what, a felony charge for possession of drugs. And you might say, well, that's all right. I mean, we just charge with drug trafficking. And that's what we heard Richard Cordray say the other day. Just charge with trafficking. Well, trafficking in Ohio requires more. Trafficking requires sale or offer to sell or some sort of transportation with the intent to distribute. There is no possession with the intent to distribute in Ohio. So it is totally outside of our ability to charge a trafficking offense for possession of large amounts of drugs. But even the way it's written, and because it freezes in the Constitution the amounts of drugs, and what the Chief Justice pointed out is simply this. If you have 20 grams of fentanyl, it would be a misdemeanor, as written, or as intended. Okay? Well, just so you understand, fentanyl, we just had a case later this month where prosecuting a woman for trafficking heroin laced with fentanyl, causing a death of a young lady. In this, if you have 20 grams of fentanyl, and so you understand, a gram is approximately the size of a sugar packet. Okay, it takes 2/1000ths of a gram to kill someone, an adult man. So a gram would kill about 500 people, 20 grams about 10,000 people. Under this proposal, this gets outside the 25% reduction, but under this proposal, possession of enough drug to kill 10,000 people would be a misdemeanor with mandatory probation, no jail, and no ability to do anything other than impose a maximum of $1,000.
So I'm going to use my moderator's privilege to follow up that point, which is say you just mentioned a case where you're prosecuting that woman for trafficking.
In that particular case, yes. In that particular case, but that is a trafficking case. That's not a possession case.
I understand, and that's my understanding is there are trafficking cases and there are possession cases. I actually really want to follow up with the idea, I don't think you want to make you represent the Ohio prosecutors writ large, but am I wrong to be confident that if issue 1 were to pass, prosecutors would be eager to get the General Assembly to pass a possession with intent to distribute statute to supplement Ohio's existing law?
Absolutely, and yes, I've already written a memo actually on that.
And I assume you don't think that statute would violate the terms of issue 1?
Well, here's the thing. In terms of convincing a jury, I think about 5 packets of sugar sitting there doesn't seem like a lot of drugs. And so what we have to do is convince a jury beyond a reasonable doubt that that amount of drugs is not personal use. It's really
Isn't that how our system's supposed to work, though? That you don't get to do things unless you can convince a jury?
Absolutely, but why should? But understand, that's enough drugs to kill thousands of people. Why should I have to go to that extra step to actually show trafficking when that
Because
amount?
that's what the law provides.
No, not at all.
Correct. Right now, that's the debate. The debate is whether you should have to prove that in order to be able to bring the hammer down. And that's absolutely a good crystallization of what's before the voters next, right? Is whether that level of proof has to be established in order to get the punishment that you want to be able to bring to bear in that type of case.
Yes.
Yeah. Okay, good. Which is what I think is true. All right, good right here.
So I want to talk, this question is for Mr. Phillips, but so when you were talking about what victims might want, and then also, saying when do they get out? So I was a victim and did not go through the system, but if he had, I wouldn't want to know when. I would want to know that I would be safe when I got out. So I have yet to hear an argument that convinces me that this incentive for therapy is not something we would want, because it has been doing so much that therapy and classes do help. Why wouldn't it? I'm still not convinced we wouldn't want to incentivize that.
Okay, well, first of all, and I don't know where you're a victim of, I'm not going to ask you, but we talk about being a victim. You can be a victim of theft, or you can be a rape victim. You can be a victim of domestic violence. So victims have obviously different perspectives. I'm just telling you anecdotally, from my experience, when a victim asks that, when are they going to get out? That's why there's truth in sentence. Okay, and that's gone by the wayside to a large measure, but it's going to be more here. But we took a look at just some of the cases that these people may qualify to get out. I'll just tell you, we talk about a bank robber getting out. Okay, bank robbery is serious, right? But there's also a man who would qualify if he's nearing what would be 75% of the sentence if he's done, or he would qualify otherwise. He attacked his girlfriend, grabbed her hair, slammed her face into the ground, and broke all of her teeth out. Okay? He would be an eligible person to get out. We have a child abuser who bashed the child's head into the wall. That's his term. So that bashed him into the wall. And to make him cry, shook him violently. Another child abuser threw a 1-year-old child, a mixed-race child, into the wall while calling him names. It's causing the child to go into seizures, having a brain hemorrhage, causing a tear of the ear, and then this child suffers permanent harm. That person would be eligible too. So, I get it in terms of, and no one is saying, by the way, prosecutors aren't saying we shouldn't have programs in prison. We want our recidivism rates to go down too. What we're saying is, number one, it shouldn't be in the Constitution, it should be in the state legislature. And number two, there are other policies out here. And again, even if that's the only thing you're voting on, this proposal has enough other stuff that would be able.
Last one I think we have time for, and then we need to thank our participants here.
So I think one of those major factors of this 25% responsibly program to got successful completion. I think we saw two different sides here from Professor Hopwood. Phillips talking about the ability to study the law in prison and something regarding return for adults. And I think there's a large discrepancy. And so I'd like to ask if the issue takes this into consideration as to the type of program that individuals. I can see from the writing here that we have behavioral training, job training, sort of things like that. But how much of discretion are we giving the criminal justice system to actually adequately measure the completion of these programs to shorten this programs?
I'd like to hear that from you, Shon, too, also about how the first
Yeah,
step
this is an issue that I talk about all the time with it's not just whether people will meaningfully participate in the program. You also have to worry about how correctional officers will implement the programs. So I just wrote a paper on how to reform the Federal Bureau of Prisons, and I talked about this story with a friend of mine who was at a federal prison. The warden said, listen, I want everyone trained on computers 6 months before they're released. This will reduce recidivism. People can get out, learn how to use the internet, learn how to look for jobs. You know, when I got out, I had never been on the internet, never seen an iPhone, an iPod. One of the things that really held me up was employers were saying, send me a PDF of the reference letter. I didn't know what a PDF was. So this is a really good idea. Well, what happened was the prison guard walked 5 people into the computer lab, sat them down, said, turn the computer on. Made them sit there for an hour, not touching the computer, and then when the hour was over, said, shut it off, there's your computer training. If that's how it's implemented, Congress or your state legislature or the people can vote for as many reforms as they want, but they're not going to be very effective if, when they're implemented, the correctional system is not doing it in an effective manner. And so that is a concern. But I think it's a concern both on whether or not the prisoners will do what they're supposed to, but also from the correctional officers and whether they will do what they're supposed to do. Those crimes that David mentioned, all serious crimes, all the more reason we want to incentivize those people to rehabilitate themselves so they aren't doing it a second and third and fourth time. Anyone that's coming home and is going to be released someday, we should be incentivized to incentivize them to be rehabilitated. Because otherwise, if we have a large recidivism rate, again, it's not going to benefit crime victims to say, yes, they're not going to get out for 10 years. But then when they get out 10 years later, they then go on to commit a series of other violent crimes. And so I think our disagreement is how to best do that. And all of the states that are having the most success in reducing their recidivism are tying meaningful programs to incentives, and incentives that get people out of prison early.
Sasha, I'll give you the last word on implementation of the 25% credit proposal.
Yeah, so one thing that we generally agree on in Ohio is that the programs that we have in DRC tend to be really good programs. We've had some really excellent leaders of our Department of Rehabilitation and Corrections with focus on making sure that these programs are evidence-based and effective. They've outsourced studies. University of Cincinnati did one to make sure that what works is put in. They've actually taken out programs that don't work. So I agree that there's this question of discretion. Luckily, we're in a state where so far it has been implemented in a good way. The second part is in the issue 1, it doesn't say any program, it says appropriate programming, which is something that then will be worked out through DRC. And the last piece I want to say is that currently, if a person completes a program, just sits there every single day, there's a non-discretionary amount that's given to them as kind of a bonus. Under issue 1, we're actually asking for a discretionary amount for completion. And that's because there is some amount you get just for sitting there every day, for participating, for learning, and some amount for getting all the way to the end. So that's actually taken into account here, the different levels of being part of it and what type of programming.
So thank you for that last question. Thank you for the participants. Our next panel in 2 weeks is about the implementation of the proposed treatment piece of this as well, and it's a lesson to all of us to remember that debates over passing a law is only the first part, or maybe even say the first step to reference federal debate, because how that law gets implemented can can vary so dramatically, and so we may be back with these folks in a matter of months to talk about that piece of it, depending on how the vote goes. Join me in. I hope to see you all in 2 weeks.